SJC-13470, Jane Doe v. Massachusetts Trial Court Department.
Okay. Attorney Gleason, whenever you're ready.
Good morning, Your Honors. Attorney Thomas Gleason representing Jane Doe. There are a couple issues here, Judge, that Your Honors, that we're dealing with, and that is we're dealing with the immunity provision of the Mass Tort Claims Act, Chapter 258, Sections 10J and 10B. Relative to the public duty exception, which is Section 10J, in my review of the cases, obviously the cases are many and varied, and it seems to me that it's a very factually intensive inquiry relative to the application of 10J. My understanding of it generally, I'm kind of a big picture guy, is there must be an affirmative act which materially contributes to a dangerous condition causing harm. So in terms of this situation, Judge, what we say is, obviously in our brief, we've enumerated a number of what we think were failures of the trial court, multiple ones, and I do understand that
Can I push you a little bit on the facts? So if the trial court is not on notice that he's a groper, this doesn't meet the affirmative act requirement, right? Isn't that clear? Because they may be negligent, but you know, he's on the hook, but they're not, right? Under 10J.
I can't disagree with you on that, Judge. I think that there are numerous incidents here of what we would call, plaintiff would call negligence.
So let me just press you again one step further. So that means the 2009 groping incident, they can't be responsible for under 10J, correct?
Other than the statute of limitations, of course, as well, we're not claiming that. But I would agree, Judge, that
there's no prior indication of any groping before 2009, right?
There is not, Judge.
So your 10J argument only potentially is applicable to the 2014 incident after the 2013 groping, is it right?
Correct.
Okay,
and why we say, Judge, factually, that we think that there's enough evidence to prove notice to the trial court.
Right. I was going to get there. Go ahead.
I think it boils down to a number of different things. Is number one, we have a plaintiff who's going to get some credibility because relative to the 2014 incident, at least one aspect of it, probably the most serious aspect of it, there doesn't appear to be any dispute that there was that she was removed from a cell, taken to a room that was not accessible to the detainees, go in through a locked door where she says there was sexual contact that was occurred. Yeah. That's admitted.
Yeah, I think on the facts, this is an immunity case, but on the facts, that you have a very strong case as far as the court officer goes.
Correct, but I think, Judge, putting it all together for you is that first you have somebody who has some credibility. Number two is you have proof, independent proof, and I don't think it's a disputed fact in this case, is that she did give notice to New Hampshire in 2009 that something.
But there's no indication they've communicated any of that to the trial court, correct?
No, I would disagree with that, Judge. I think that's the second part, that we know that she communicated it to New Hampshire. The third part of it is and very frustrating in a situation like this, Judge, is during discovery, of course, as you might imagine, one of the areas of inquiry we had did the trial court know about the 2009 incident? Mm-hmm. Did you get notice? Did somebody tell you? Did New Hampshire tell you? And The responses that the plaintiff received is that there was no information concerning that. There was none forthcoming. No incident report, no knowledge. The depositions that were taken didn't prove fruitful in that regard.
But doesn't that hurt you? I'm confused by that. That's not helpful to you.
It's not helpful to us, Judge, until you get to the very last deposition that I took. And that if you look at the deposition of, and it's in the materials, and that is the deposition of the Deputy Director of Security, he indicates, and this is at the appendix at 778 through 781, one of the final questions I asked to the final person I'm deposing is, did the trial court know anything about a 2009 incident? And what he reports at this point in time is he says that he just had a conversation with somebody I had deposed two days earlier, who was the Regional Director of Security, who told him that there had been an incident in 2009 and gave some specifics, that it had been investigated by the police, that it involved something that happened in an elevator, and that it had been unsubstantiated.
I think that's the 2013
No,
incident.
this is the 2009, Judge.
It is? I thought the unsubstantiated one was the 2013, July 2013. I may be confusing them. 'Cause the as I read Judge Liu's findings and what the defendants say is that the 2000 and the prior one reported to New Hampshire was not, for whatever reason, transmitted to the trial court. And then there was a July 2013 complaint against the court officer, and that was unsubstantiated. Am I getting that wrong?
There are two separate incidents. Right. July 13th, I don't know, there's the security people that I deposed, they had some knowledge of it.
I didn't read the depositions, and you were there, so I don't know if I'm getting it wrong.
Yeah, a little bit off, Judge. Is the 2013 incident, there was no incident report filed. One of the court officers that we deposed, the assistant chief court officer, recalled that there had been a complaint, and it actually was a police officer from Lawrence came to the trial court and said, somebody came into our department and complained about this, and apparently there was no investigation, there was no incident report.
But that's the 2013.
Correct.
Right.
On the 2009 is that this last deposition that I'm taking, and it's at the appendix at 778 to 781, is this witness, who is the Deputy Director of Security, said that the Regional Director of Security had told him a week before his deposition about the fact that there had been a 2009 complaint that was made, that it was investigated by the police, that it was unsubstantiated, it involved an elevator, and a specific question that I asked was, because I was, frankly, I'm real surprised at this point that I've received no information that they know anything about it, and then this very last witness is saying this to me, is that this witness, I would ask the question, well, do you have any information, did he tell you anything about New Hampshire informing you of this, or informing the authorities of this? And this person confirmed, yes, that's what the Regional Director of Security told me.
Is this in your brief anywhere? I mean,
well,
I read excerpts at 718. I may have missed the 780. You sure it's 780 as opposed to 718? Because I'm looking at the actual deposition excerpts on page 718, and I'm reading the wrong ones. I just want to make sure. 778 to 781. And I do cite it in the brief, Judge.
Attorney Gleason, could I just ask you about the 2009, because I'm slightly confused as to whether or not this really helps you or hurts you. But even if all of that is true, if at the end of the 2009, whatever investigation was done, that it was unsubstantiated, does that help you with respect to notice for the trial court?
I think, Judge, that the focus here that we have, when I'm looking at this immunity issue and trying to sign a specific type of negligence that involves an affirmative act is one of the requirements under PREA, And one of the requirements under the policy manual is the requirement that there be the filing of an incident report. That triggers a whole bunch of things. It's something technically will get distributed to other people within the trial court. It triggers an investigation. It triggers all kinds of things where it gets out there into everybody's knowledge. Technically, under the rules of the policy manual, it goes, in certain circumstances, in serious cases, it goes to the justice in the court.
I'm sort of confused by that, Mr. Gleason. First of all, I thought the Federal Rape Elimination Act issue, putting aside whether it's been adopted and what Massachusetts has to do to be able to receive the 5%, put aside all those issues. I thought that went to the 10B issue. I don't see how this issue helps you on 10J, whether there was an affirmative act that would constitute liability when the action is being taken by a third person. How does the Federal Rape Elimination Act help you in any way with the 10J issue, as opposed to, at least theoretically, I understand how it helps you with the 10B issue?
Our theory on the 10J issue is that, to put it, generally speaking, is that Mr. Martinez should not have had any access at all to my client, based on the circumstances. If the trial court...
It's not an affirmative act.
Because it's an
I think it's hard, but how is that an affirmative act as opposed to not doing
Or the original cause is the...
Yeah, even better, or the original cause.
Well, I think it's an affirmative act because it's in the spirit of the cases that I cited, Bonnie, Baptista, and Devlin. In those cases, basically what happened is that there was some act by the government whereby individuals were allowed into areas where they shouldn't have been. And by that act of allowing that person into those areas, that's what creates the dangerous condition. There's nothing wrong with other than the areas of where we say it's deficient, there's nothing really wrong with the Lawrence lockup. What's wrong with it is when he's allowed access to it.
How is this different than the school bullying case that we had with a school let the bully on the loose and the poor kid was thrown down the stairs?
Is that Brum, Judge? Is that the Brum?
Cormier.
Yeah.
Cormier. The difference is that, as I understand that case, is that I believe it was a young child who was pushed downstairs and received some tragic injuries. There had been some general notice of bullying, but I don't know that there was I don't recall that there was specific notice that the individual that pushed the child had had any notice about that individual child.
So your argument is that the original cause is the lax trial court practice, not the rapist CEO, essentially.
I'm sorry, I misunderstand, Judge.
The original cause, to get under J, the original cause of the harm to your client has to have been the failure of the trial court to supervise this person having notice.
You know, I wouldn't put it that way, Judge. I think that the affirmative act is...
Then using the original cause language, how would you put it, Mr. Gleason?
Yeah, is the affirmative act is first is the enormity of this situation. Is we know my client made the accusation, confided in the New Hampshire authorities in 2009, we know that. And then a few years later, here she is in the same position again, and who is it that's taking care of her and supposedly safeguarding her in a situation where she's detained and helpless and shackled and handcuffed and in a cell? It's the same individual she complained about. So the affirmative act is that we say that the trial court had notice, and they nevertheless acted. They allowed this person to continue to be in that area, be in the lockup, be in the position where he could open the cell door, where he could take her out of a cell, where he could bring her to a room, a private room, enter a locked room, and where he could sexually assault her again.
Well, Attorney Gleason, so I know you know this record, and we're going to pour into it after the fact, but those two things, I just want to make sure I understand what you're saying. So first, you're saying in the record, the 2009 complaint to the New Hampshire authorities was communicated back to Massachusetts.
Yeah, let me be specific, Judge. Is that at the appendix at 778,
Can you read us the-
781.
Can you read us the relevant portion of that? Because I don't have, for some reason, I can't pull up that page.
Because my understanding of, and again, you know it better than I do, that neither of the complaints to New Hampshire were communicated back to Massachusetts.
That's true based on the record, Judge, in terms of what, there's nothing in the record other than what I'm going to read to you that New Hampshire was ever notified.
That New
But this-
Hampshire ever notified
Massachusetts.
Massachusetts.
Right.
Okay, what are you going to read us?
Okay. It's a little bit lengthy.
Well,
From what I
Just drill
understand is it says, New Hampshire told some unspecified Massachusetts authorities about this, but not the trial court in particular, right?
It didn't say the trial court in particular.
Okay.
It does say, did he, portion of it, and this is at page 779, appendix 779, question, did he mention the New Hampshire authorities? Answer, he mentioned something about somebody up in New Hampshire. He didn't say who, just New Hampshire. Question, did he say that New Hampshire had alerted the Massachusetts authorities to something that had happened in the Lawrence lockup? Answer, yes.
We need to
And
know
then it
who
goes
that-
on.
I mean, not to state the obvious,
Right.
but we need to know who that Massachusetts authority is for you to get into the affirmative act.
right.
Well, I don't know, for summary judgment
You
purposes.
can call the police, right? I mean, and they didn't, and they may have decided it was junk. But you need to show, right, that for this to be an affirmative act, you need to demonstrate that basically they knew of his past practice of groping and put her in front of him. You need that level of knowledge for this to be an affirmative act. Otherwise, it fits within the negligence that they're protected against, and you can only sue the court officer himself, right?
I would disagree, Judge. The fact that I can add for you is on, because it says what it says, and that's the evidence that we have. But what I can add for is maybe just the blatantly obvious, is that the information that this is being reported to New Hampshire is coming from the Regional Director of Security for the Mass Trial Court. So I think putting all of those things together as circumstantial evidence.
But 5 years and years later, while he's preparing for his deposition, right?
Right.
Where he's trying to, it's a little different, right? He may have heard this as part of, you know.
Let me add one other thing, Judge. 2 days before I deposed him, the Regional Director of Security, I asked him, do you know anything, any information about a 2009 incident? The answer I got was no. So, you know, I think circumstantially, when you put all of that together, do we have enough to get over the bar of summary judgment, looking at a light most favorable to the plaintiff? And do we have potentially a preponderance of the evidence? You know, I think the trier of fact could very well conclude on this evidence. Trial court knew. And I don't know, I'm way over, so
By the way,
unless the
did you
court
have
has
a
some further
follow-up?
questions.
Is there anything in the record indicate whether you had a follow-up deposition with the person you now are saying lied to you?
No, that's the last deposition that I took, was the individual who said he had the conversation that I indicated to you.
And was there something that precluded you from going back?
I'm not sure whether we were running up against a discovery deadline or not, Judge. I don't know.
Okay,
All I
but
know
you
is
didn't ask for an extension, for example,
no.
of
I
any deadline?
no, I did not ask for any extension. I did at the conclusion of this deposition of the individual who told me this right at the end, and counsel and I had some words about it. Is that I did leave it open. I didn't conclude the deposition, but other than that, there was no other follow-up.
Okay.
With that,
Thank you.
thank you.
Okay, Attorney Ernst.
Thank you, Madam Chief Justice. Good morning, Your Honors, and may it please the Court. Ben Ernst on behalf of the appellee, the Trial Court Department. With me today is Assistant Attorney General Dan Cromack. The actions of former court officer Martinez are horrific, indisputably horrific. But as awful as those actions were, Superior Court here correctly concluded that the negligence claim against the trial court for failure to prevent those horrific acts is barred by sovereign immunity. And I'd like to start, if I could, with 10J and the questions that were being addressed to my brother.
And particularly, it would be helpful if you address this back and forth about 781 too.
Certainly, Your Honor. This confusion is nothing more than confusion. It was undisputed for the purposes of summary judgment that the trial court had no knowledge, tragically had no knowledge of these 2009 or 2014 incidents until April 2015. I say tragically because they were bravely reported by Misto in 2009 to New Hampshire authorities who failed to transmit that report to Massachusetts.
How do we
So-
know?
yeah,
Go ahead. Justice Wendell, go ahead.
So, on 779, it does appear that there is testimony to the effect that there was knowledge of some Massachusetts authority and an investigation done, and that is part of the record. I'm wondering if that's true, how it's possible that it's undisputed that until April 2015, the trial court had no knowledge.
So let me address that specific confusion. In this deposition that was discussed in my brother's argument, Mr. Connolly is asked the question. It begins, I think the back and forth begins with the question, other than the 2014 incident, sir, are you aware of any other incidents involving Mr. Martinez? And he says, well, I heard, as part of my preparation for this deposition, that there was a 2009 incident. Wasn't aware of that before. He's referring to the 2009 incidents at issue in this case. And what he's referring to is the fact that those incidents occurred, not that the trial court had knowledge of those incidents prior to 2014. And I think that's absolutely clear from the record, which admittedly is a bit confusing, but you can look at the testimony. He says, I spoke with a colleague of mine who is also being deposed, Mr. McPherson. We were chatting, and I said, gosh, I never heard about these 2009 incidents.
What about the July 2013 complaint by another detainee?
So that complaint was investigated by the Lawrence Police Department. And what the record shows is not only was the complaint investigated by the Lawrence PD, but the trial court assisted with that investigation, including by pulling and reviewing the available security footage of that incident. Based on that investigation, the complaint could not be substantiated. And when we don't have a substantiated complaint against Mr. Martinez in
But the
2013.
2013 incident says that the groping happens after she leaves the elevator, right?
That's correct, Your Honor. It's,
And
I
the-
think.
And the video is of the elevator. So I read also the police report goes further and says that there would be people standing outside of that area. Is that what we should rely on? That, or it's just looking at an elevator video when you know that the groping occurred after he left the elevator. Isn't that helpful? Is it?
What I would say, Your Honor, is that the trial court assisted the Lawrence Police Department in the investigation. They were asked to pull the video. They pulled, my understanding is they pulled what they had, and when they reviewed that video didn't help substantiate this complaint. But the Lawrence Police Department was running the investigation.
So your position is, when we look thoroughly through this record, the only thing we're going to find as far as prior knowledge of anything amiss with Martinez is this July 2013 another detainee investigation that was unsubstantiated.
That's correct, Your Honor.
All right,
That's correct.
That's your position after we review the
It
record.
is. And I'd like to point out that
If we don't agree with you and we find that there is notice, does that preclude your 10J defense?
I don't think it does, Justice Gaziano, and that's the point that I'd like to address now. I think this court has shown in decisions like Brum and decisions like Cormier that mere knowledge of a dangerous situation, even extreme knowledge that a student is going to be stabbed that day in your school, that knowledge alone is never enough to transform a failure to act into an affirmative act.
Except here we're putting, the trial court is putting this known dangerous person, assuming the record substantiates that, in charge of an extremely vulnerable person. And so I don't understand why that's not an affirmative act that really is actually creating the condition that caused the harm.
To answer your question, and not to fight your hypothetical, but of course that's not our case.
Right,
But
and
even
we'll go back in the record
if it
and
were
look
the
at it,
case
yeah.
that the trial court did have knowledge, you would still need to identify an affirmative act that materially contributed. And here, there's no record evidence that Mr. Martinez was directed to engage with Ms. Doe. In fact,
They don't have to go that far, right? If the trial court knows he's a sort of a serial groper, or even knows he's groped a detainee in the past, and then they put him alone with a female detainee, isn't that enough to get to the affirmative act exception?
it very well may be. That hypothetical scenario, Your Honor, which is not this case, that very well may be.
I get it. If they have no notice, it's not an affirmative act. But if they do have notice, it may very well be an affirmative act, right?
Right, and I think the Bonnie W. cases illustrates this. In Bonnie W., what this court held was that there was no 10J barred the claim that was solely based on a failure to supervise. But because the parole officer in that case had knowledge that the individual was dangerous, he knew that he was a sexually violent person, to take that knowledge and then affirmatively recommend to the trailer park where he was employed, you should continue to employ this person. That's an affirmative act, and it's enough to meet the material contribution standard because of that knowledge. The reason why our case is distinguishable is because we don't have that knowledge and we don't have an affirmative act.
If you did have that knowledge, would you still have the discretionary function available to you?
We would, Your Honor, and I'm happy to address 10B.
One last question on the 10J before you do. This 2009 complaint, assume for the sake of argument that there's enough specificity to say that that can be localized back to the trial court. I thought there was an investigation and they found they couldn't substantiate that complaint.
I'm
Am I wrong about that record?
As a factual matter, as to the 2009 and the 2014 allegations, it's possible that that testimony refers to the criminal proceedings against Mr. Martinez, who immediately after the 2014 incidents, which were reported, the trial court learned about them, this individual was no longer employed by the trial court. He was criminally prosecuted.
I'm just speaking about the 2009 complaint to the New Hampshire authorities. And what happened with that complaint? So if that's in the record, my memory was that it was investigated and they didn't find anything.
I don't believe that's correct, Your Honor. I think that what the record shows is it was simply never transmitted to a Massachusetts authority. And this was part of the civil case that appellant brought against that New Hampshire prison for failure to transmit that report. That case ended in a settlement with the prison.
Thank you.
On 10B, is it your argument that our failure to implement PREA takes us out of discretionary function?
It does not take us out of discretionary function because PREA at the time, both in 2009 when there were no PREA guidelines and in 2014 when there were PREA guidelines, but Massachusetts, the Commonwealth, had permissibly submitted an assurance that says we are working toward it. That Massachusetts, and along with 41 other states in the nation, had submitted that assurance. So PREA didn't prescribe any specific course of conduct either in 2009 or in 2014.
There has to be a statute or regulation or established practice that we failed to follow, and you're saying that because we hadn't fully adopted PREA, there's no standard So anything the Commonwealth did was discretionary.
That's right. So at step one of the analysis, Your Honor, we would say that there is no statute or regulation that strips us of our discretion. And the trial court maintains great and weighty discretion to implement security policies throughout the trial courts in the Commonwealth to protect people visiting the courthouse, to protect detainees, to protect judges.
Including the failure to use same-gendered matrons, et cetera.
Right. So the policies which are in the record, the policies that were in place, which are in the record in this case, don't require that every single instance when a female detainee is transported, that she be transported by another female detainee. And the record is quite clear about why that's the case. These policies were the product of a deep deliberative decision-making process. There's a policy committee. That policy committee is listed in each one of those policies. The policies are put together by the committee, and what are they doing? They're weighing alternatives. They're weighing the resource constraints that the trial courts have and making those tough decisions. That's the core of what 10b protects. It's the core of what the Whitney case said. We shouldn't be questioning those judgments in a tort case because of the deleterious effects that could have in the process.
Could you answer Justice Wendland's question about the relationship between the discretionary function and the affirmative act? Just if there's knowledge that he's a groper, even though the sort of the overall management of the courthouse is a discretionary function, that doesn't protect you, does it? He'd still have the affirmative act. I'm trying to understand the relationship. Just because it doesn't meet just because the PREA, whatever it is, doesn't satisfy the discretionary function issue, there's still this affirmative act avenue if you have knowledge, right?
I would agree that the immunities in Section 10 operate independently of one another. So finding for...
If he doesn't satisfy the 10b requirements, that doesn't protect you from the issue under 10J, right?
Right, and put another way, Your Honor, if 10J bars this claim, it doesn't matter whether 10B applies or not, and vice versa. If 10B bars the claim, but this court, for whatever...
You have to establish either 10B or 10J.
That's correct, Your Honor. And that comes from this court's decision in the Brum case.
But I want to follow up on that because he's got different theories of liability. He's got the liability theory, look, you should have been doing what PREA is doing, but he also has a separate theory of liability, which is you knew he was a groper and you put him with her. Just because the PREA stuff doesn't get you, just because he doesn't meet that prong, he can still, that doesn't protect you from the knowing groper issue, does it?
I would quibble with that just...
And I don't know the answer, it's a question.
Certainly, Your Honor. I would just tweak the framing there, and what I would say is I do believe that the appellant's claim in this case was predicated on alleged failures of the trial court to act. What failures? It was consistently throughout the case in discovery, in the complaint stage, it was a failure to implement particular security policies, failure to design security policies that could have prevented these assaults. And so while there is this allegation now on appeal that an affirmative act here was the failure to remove Mr. Martinez, that's always throughout the litigation been cashed out in terms of you ought to have had a different type of policy that would have allowed you to earlier detect Martinez's behavior or take him out of the equation.
But if you had had a cause of action that made it clear that we're not alleging anything wrong with the policy in this particular count of the complaint, what we're complaining about here is that you affirmatively caused this, 10B doesn't prevent the cause of action.
I would agree with that, Your Honor. If there were two distinct theories of negligence, there's a scenario in which you could imagine that one of those theories surviving, even if 10B applies.
That's not clear in this complaint from your perspective.
It's not clear in this complaint. It's not been clear in discovery. And I would also say it's never been raised by appellant at any stage in this case, least of all on appeal here. that there's some slice of the theory that should survive even if 10B applies. I see that I'm close to out of time, and if there are no more questions, I'll rest on the briefs.